This is the first, maybe only, screenshot video for weeks 9 to 10 in the civil practice course, and it's about the topic of pleadings, which we'll get to in just a bit. Let me just make a few observations about where we're at in the course. If you look at the syllabus or the what you need to know outline, both of which I have posted, you'll see that we're in a 2-week period at the end of which you should be through chapter 22 of the Buffalo Creek disaster. So I'm going to suggest that what we're doing right now in the course isn't going to take you an awful lot of time concerning pleadings. I'm not suggesting it's unimportant, but I'm just referring to time that you need to spend. And I would encourage you then to get yourself up to speed on the Buffalo Creek disaster. And if you're nowhere near close to chapter 22, you're beginning to reach the point where you're going to be behind in a way that just isn't going to be effective for you. So take the time now to hunker down with Buffalo Creek disaster and come up to speed. I really think that if a person has any interest in the law, the Buffalo Creek disaster is just an excellent read. It's an interesting book to read, but in any event, get yourself caught up with that. We're almost done with the book, by the way. After you get through chapter 22, I think there's only 9 more chapters left in the book. And if you have any interest about what's going on, we're getting to the end of the story. The second thing I want to say, and this gets us into this video, is please dig out the forms handout. We've been dealing with the textual outline, but there was a second handout that I posted. It's called Forms, and that handout should have been, but was not paginated. It has unnumbered pages, so you're going to have to do some counting. But get that out, and when we're going through this material, if you were looking at pages 21 through 24, this exercise that we're doing is going to be far more useful to you, because we have, if you will, real-time pleadings that were used in different lawsuits. What are pleadings? We could say generally from the glossary of terms that they're written statements that are filed with the court that describe a party's legal and or factual assertions about the case. And lawyers who engage in representing clients in civil litigation and paralegals who are working with those lawyers are going to be dealing with pleadings in civil lawsuits on a regular basis. Again, we can return to the 2 types of civil lawsuits in New York, which would be action and then second special proceedings, sometimes just referred to as proceedings. And what I point out is most of our bread and butter lawsuits, that's an old-fashioned term, our basic lawsuits in New York are actions, personal injury claims arising out of motor vehicle accidents, divorces, breach of contract cases, and we're going to be really devoting our time more to actions. But again, let's just stop for a moment and consider what's going on in a case. This is where it's a little bit more difficult dealing with this stuff online rather than in person. But we have, let's put ourselves in the place of a lawyer or a law firm that's going to be bringing a action on behalf of a person against someone. So their client is the plaintiff, and the person or entity to be sued would be the defendant. And so we've got to file the case. We've got to commence the case. And of course, looming in the background would be notice of claim considerations that we should have already been concerned with if our claim is for monetary damages against a governmental unit. And we need to file a notice of claim. If it's a non-governmental unit, we don't have to file a notice of claim. But in all instances, we have a statute of limitations to be concerned about. So we have to make certain that our papers are ready to be filed. Our papers oftentimes today, of course, being pieces of digital information, but our papers are ready to be filed clearly before the statute of limitations has expired. And in all likelihood, the two documents that we will be preparing will be a summons and also a complaint. We're also going to need in New York State Supreme Court to file an application for an index number, so that will be something we need before we can actually file the summons and complaint. This is kind of administrative stuff. It's certainly not unimportant, but it's a kind of OJT that you really are going to need to walk through, because then we get into electronic filing and so on. Believe me when I tell you, if I can do it, you can do it. We need a credit card and an account, etc. But I want to focus on the complaint. Almost always, I've had a few cases representing plaintiffs where I didn't file a complaint, I just filed a summons. But almost always, you're going to file a plaintiff summons and complaint. And what'll then happen is the defendant, and that's something we're going to serve, we've talked about that, serve personally, we hope, on the defendant. There's a possibility it could be served on someone else if it's not a divorce case. But the defendant is then going to secure an attorney, we hope, and the attorney is going to respond to the complaint with a second pleading known as an answer. And the answer, when we look at it, when we get it for the plaintiff, we're going to see that it may contain, among other things, a counterclaim. That is a claim that the defendant is raising against our client, the plaintiff. And if it does, the plaintiff must then respond with a third type of pleading known as a reply. So we've got complaint, answer, and reply. In special proceedings, by the way, we've got, rather than the complaint, a petition. We have an answer, and we could have a third pleading, which is also known as a reply. The answer in a special proceeding will not contain a counterclaim. Don't worry about that. But it may contain something known as new material, and don't worry about that. It's really beyond what we're trying to do. But we could have those three different types of pleadings, except it's not a complaint, it's a petition in a special proceeding. So let's talk about drafting the complaint, answer, and reply. And what I want to point out is that rarely is anybody sitting down in front of a blank computer screen with a keyboard and just creating a pleading from whole cloth. We're always going to have, it seems to me, I know I've always had, even before we had computers, some type of model or template to work with. And oftentimes that's going to be in-house, meaning we're working in a firm, and this isn't our first rodeo with this type of complaint, by way of example. And we have a sample that we obviously have to tweak, but that we can use. Also, of course, there's our Westlaw or our LexisNexis research, our digital law library, and they have forms that we can use. Sometimes I know that I have had some success, even with pleadings, if it's a special kind of case, in using as part of my background template just a Google search. And the other point I want to make, because it's been very useful to me, is that if it's a kind of case I just have never done before, and I don't have a crowdsourcing opportunity, meaning nobody I know has done it either, then I will try to find a lawsuit where that type of pleading was used, and I'll then look at the record on appeal, at least for New York State Supreme Court. The record on appeals are in all things not yet been placed online, but they've been put on, what the hell do you call it, microfiche, and you can look at it. It's worth the effort if you don't know quite what you're doing. And so you find in that case what the complaint looked like by way of example, and you copy it, and you then again use that as your sample. Whenever we're doing in-house samples, law library samples, microfiche, record on appeal samples, we have to be very careful to adopt the sample to our case. Another practical observation I want to make about drafting pleadings is that lawyers and law offices have different styles. And the complaint contained in your handout would be drafted differently by other lawyers. And nothing wrong with the way it was drafted, nothing wrong that it would be drafted differently by other lawyers. But I guess we could end with this for our purposes in this course. If you're a paralegal or a new lawyer in a law office, you're obviously going to be guided by the style your employing attorney or law firm uses. So let's get to the complaint. And again, I'm hoping you're looking at the complaint in the handouts, and you're going to see that what I'm saying is going to match it. The complaint sets, obviously at the top of the case, or maybe it's not obvious, but now you're looking at it, it's got the name of the case, the name of the court, and the type of pleading, and a place to put the index number. And then we get into the body of the complaint. Different lawyers start their complaints a little bit differently. You could say just easily Plaintiff John Jones for his complaint alleges. But then what you do is put forth in consecutively numbered paragraphs. Well, I guess they would be consecutive unless we were crazy. General factual allegations that the plaintiff is making against the defendant that, if true, set forth a legal theory of recovery. Sometimes in New York, this is referred to as setting forth a valid cause of action. So one point I always used to make in class is, well, how do you know if you're drafting a complaint to go from paragraph 4 to paragraph 5, for example? And I think just a rule of thumb is whenever you're asserting a new allegation or a different allegation, then you're going to go to another paragraph. But believe me, lawyers are going to have, again, different styles, and no lawsuit ever turned on the fact that there was too much or too little in a paragraph in the complaint. It's a matter of style. I think employing lawyers are going to be, I know I'm very fussy about the way this stuff looks, but in terms of the case getting thrown out or not, you're rarely going to see that happen because the complaint was so poorly drafted. And then even if it gets thrown out, a court's going to give the plaintiff's lawyer a chance to redo it. Okay, so what is important in the complaint is that the allegations have to, if true, establish a valid legal theory of recovery. The complaint you folks have is a complaint about a vehicular accident. In New York State, we certainly have to allege that there was, a certain time and place an accident. The plaintiff was injured, and the injury was a serious injury under the no-fault insurance law. The accident and thus the injuries were caused by defendant's negligence, and as a result, the plaintiff sustains damages. And certainly under these rules, the complaint we have is a good one. I'm going to stop at this point because we're going to need a second video.